So getting right into it, let's get to our first story. Hootsuite is bullying bloggers about the use of their logo. And I saw the story come up on my newsfeed on Facebook and thought it was very interesting because it was getting a lot of traction and engagement from Ian Anderson Gray, who posted the story. And I started getting into it, and I've had some experiences around trademarks and copyright and so on from working with Andrei in the past. And so getting into this is what he said. He posts, "I'm really not sure where to start on this one. Last week, I received an email from someone in Hootsuite's legal department that I violated their brand assets terms of service, and that if I don't sort it out, they will take all necessary legal action." Wow. Said, firstly, I've never had anything against Hootsuite. It's an okay social media management tool. It's not a tool I've used much, but I have recommended it to some businesses over the years. And he goes on about how he wrote a blog post. He's got 2 blog posts on Hootsuite. One was called 7 Reasons Not to Use Hootsuite, and the other one called 7 Reasons Why You Should Use Hootsuite. And he wrote a review about their product. So what happened is, he took screenshots of their product for his blog post. So of course, those screenshots would end up having the Hootsuite logo in them. And also he had a banner image at the top of his post that also included the Hootsuite logo. So they asked him to take some certain actions to remove the logo from the post. So what it appears to be is that they did not like his review and in a sense are saying, take it down. That's kind of the feeling going on here. This post has accumulated almost 200 comments of people going, "Wow, this is not cool." Ian made an update in one of the comments here. He says, "Update. I think I pretty much removed the logos, and I've set up a redirect from my 7 reasons why you should use Hootsuite to 7 reasons not to use Hootsuite." He said the should article was getting pretty old, anyways. I've changed the Hootsuite logo on the infographic to a hand-drawn chalkboard font. The thing I am unsure about is where I've taken screenshots of the Hootsuite website and the product in which the Hootsuite logo appears. Is I don't need to remove those, do I? ? So really quick, we got to give a shout out to Ian. I talked to him. I told him we were going to cover the story. He was cool with it. So I just want to give a shout out to Ian. His name's Ian Anderson Gray. You can check out his website. It's iag.me. Great domain name, by the way, Ian. Love that. He's also got a Facebook page, and I actually I've been friends with him for a long time on Facebook, but don't really know him personally. But I see here that he's actually doing some education for people on doing video and video marketing. You can see his latest show here is about how to set up a live show on a Mac, which is kind of what we're doing here with Riverside. But we were talking before how we don't really like Riverside. I don't know what he's recommending, but we should probably watch a show afterwards. This is the updated blog post. I have it on my screen right now. It says 7 reasons not to use Hootsuite. And I used the Wayback Machine to show you what it used to look like. It used to also say 7 reasons not to use Hootsuite with the Hootsuite owl in the banner image. And let's bring on our first guest of the show, our expert, Andrei Mincov, trademark expert, coming in to tell us what is going on here, Andrei. What's going on,
baby? Hey, good to see you, Matt. Good to see Andrew.
Yeah, Andrei, I got to say, I'm really excited to have you here on this episode to talk about the story here, because I mean, Matt and I are hardly the experts on this. We're digital marketers, we're social media experts, and I've certainly had my fair share of interacting with community members that are using the company's brand, the company that I'm working for at the time, brand or logo and whatnot. And here I feel like I feel bad for this Ian Anderson Gray fella. I would love to know what your input is on Andrei as far as, did Hootsuite kind of cross a line here? Have they done any damage to their audience members, their customers by behaving in such a manner, or are they well within their right that they can dictate such terms to someone in the public?
All right, so let me start with just putting out a general framework here, because one thing that most people don't realize is that law on the books is very different from what you can get out of it in practice, right? Like in theory, Canada is supposed to be a free country, right? We know how that went. And there are millions of other examples how countries disregard the rules of law, how people disregard, how companies disregard the rule of law. And what I'm known for saying is that it doesn't matter whether you're right or whether you're wrong. The only thing that matters is what you're going to do about it and what the other side is going to do about it. And in this case, right, you should look into that from that perspective in the first place, because if you don't, it really boils down to trying to figure out the legal logistics, and legal logistics only matter if the matter ends up in court and then gets appealed, and then we get a final decision, which in 99.9% of the cases will never happen. So, and it's not just
is this going to be a Supreme Court?
What's that?
Andrei, is this going to be like a Supreme Court thing? Like, do they need to like subpoena him or like serve him like through a processor in order for it to be official? Like, you get an email like this, can you just ignore it?
Yeah. Yeah.
You can, right? Like, if they were going to be serious, they would go get a processor. They would file what you call it, an affidavit in this case.
Well, I mean, look, I have a good lawyer friend, and he's got a great saying. He says, he says it like this: people who want to litigate, they take you to court. People who want to threaten litigation, they send demand letters.
Yeah.
Right. And,
so you think this is a scare tactic? Hootsuite is just, they're being bullies.
Well, absolutely. Because look, again, going back to whether they're right or whether they're wrong, even that is questionable, because so it's pretty clear with the names by themselves, right? You can use other companies' names, even if they're trademarked, when you write about those companies, when you write about their products, not in a way to compete with them, right? So if you're writing an article about how good or how bad an iPhone is, Apple cannot do anything to stop you from using the word iPhone or the word Apple in it, simply because you are telling the story about the product, about the company, and there's no way you can do that without mentioning their trademark name, right? So trademarks, there's only trademark infringement when you are using the trademark, and using is a legal term, which means that you have to be putting that name either in your advertising on products that you are making available to the public, right? So if you are reselling something, right, that could be trademark use unless you're reselling a legitimate product. If you're advertising something to compete with them under their brand name, that's trademark use. But when you're just talking about how good or how bad they are, that's not trademark use. It's not actionable. You can't really do anything with it. So that's with names, right? There are two lines of thought about whether logos fall in the same exception, because in theory, you don't need to show the logo to talk about the product. And so one group of people says, because you don't need to show the logo to talk about the product, then when you use the logo, that could be deemed trademark infringement. And some people say, well, it's still not trademark use, and since it's not use, it cannot be infringement. So it can go both ways. But really, all of this, the legal stuff, matters much less than what Hootsuite lawyers decided to do about it. And what they decided to do about it is they look into that and like, hey, let's send a letter to Ian because we're big guys who have the money to pay lawyers to write letters and maybe take Ian to court. And they wanted to, they sent the usual boilerplate template. And I don't think that was a very smart decision, given how big Ian's audience is and what really can backfire out of this. So again, it's never about the law; it's about the optics of it. And here's the other thing: even if they do take him to court. Let's say they do take him to court, okay? And let's say they go through the entire process of litigation, and even let's say the judge agrees that Ian, by posting that article, infringed on their trademark rights, which I don't think they would. But let's say that did happen. Then there's always a question of damages, right? How much money does Ian need to pay? And that has to be proportionate to the loss that Hootsuite sustained as a result of that article, not from the perspective of the bad stuff that Ian mentioned in the article, but from the perspective of him using their logo. And that would be negligible. So
imagine they actually went to court for that. They would I think Ian could leverage that so much.
It's a Barbara Streisand effect, right?
What's that? Say it again.
It's a Barbara Streisand effect, right? Or Streisand. What? I don't know how you pronounce her last
Barbara
name.
Streisand. Oh, okay.
Yeah, so it's a Barbara Streisand effect.
So guys, for that, who don't know that she was trying to get some photos off the internet, and then by doing that, it made the photos even more famous. That's right. What they call the Barbara Streisand effect.
Right. So if Hootsuite wanted to preserve their reputation and their brand integrity by sending that letter, I think what they've accomplished is exactly the opposite.
The opposite. Okay, so I gotta ask you this one here, Andrei, because we've got marketers and content creators that watch and listen to this show, right? So let's talk about this. Option one was Ian could have just ignored the email completely, right? They're claiming that Ian violated their brand assets terms of service. So option A is he could have just ignored it and just continued on his business. Option B, I assume, is he could have responded and said, actually, Hootsuite, I'm following fair use by the definition of it. This is commentary and criticism. Would that be another?
For a second. Comment and criticism applies to copyright. It doesn't really apply to trademarks.
Okay.
Yeah.
And did they specifically say trademark in this? Let's see. I don't.
Yeah, they say infringement of our brand assets. What they say.
Yeah.
And that's a trademark term. Okay.
Mm-hmm.
Yeah, they used they were he put in quote that he violated their brand assets. So anytime you're using a logo from a company, I always look up to find their best version of their logo. You can look up brand guidelines, XYZ brand name. I write Apple brand guidelines, and I can go to their page on their website and they explain how to use their brand guidelines. We have it as well on Web Friendly. So in that case, Andrei, can you really comment on that, on the use of brand guidelines?
It's a great point. So there's several layers here, right? One, there's law, what you can actually enforce by law, by virtue of you having legal rights to the trademark, right? That's one thing. Then companies, some companies do create those terms, how the public is allowed to use their assets. Because by law, if you own the trademark, if you've got exclusive rights to the use of that trademark, nobody can use your brand. Again, use from the trademark perspective, and I already mentioned that. But if you are, right, they say, okay, even though nobody can use without our permission, here's our permission to you, dear world, how you can use our brand assets in order for you to feel safe that you're not violating our legal rights. Right? But they can't make those terms more onerous for the public than what the public can do without those terms. Right? So if by law, they can't prevent Ian from using that logo, if law cannot do that, them coming up with terms of service that say, you gotta do this and you gotta do that and you gotta jump and you gotta, they can't do it. That's one thing that can be safely ignored unless he gets some additional value out of Hootsuite, and that's a contract, right? If it's not a contract, then there's nothing they can do about it.
If he was a brand ambassador working with them, then of course they could say, hey, if you want to work with us, you got to follow our brand guidelines.
Yeah, and that's fine.
That would make sense. Yeah.
Yeah. So if there's a two-sided agreement, if he gets something out of it and they put conditions to that, then it's perfectly enforceable as a contract.
Yeah. I've had things with our brand, I hate when people write web friendly as one word, capital W and then friendly. And then I don't get my legal team involved. I just message them and say, web friendly is 2 words, capital W, capital F. Don't mess it up. Yeah. Right. We do the same thing. We have it with our logo. It's there's got to be certain spacing around the logo when you use it and certain colors that we want you to use, but it's never a legal enforcement. It's just hey, fix this up. It's cool. So ultimately, the solution here is that if you get a letter like this, or sorry, I should say, if you get an email like this, just ignore it?
Again, really boils down to what you want to do about it and how important that is to you. right? So if it's somebody like Ian, right, who's got an audience and who knew that he can make this post go viral, he knew that he could gather some attention to it. And what I think he did was exactly the right thing, right? So on the one hand, he put it out there. He told the world how big of a the legal department from Hootsuite really was, right? But on the other hand, he did remove the logo from the post. So in theory, right, he's complied with their demands. So I think that was a perfect response on his front, because he really didn't care whether the logo is there or isn't there, right? It wasn't the reason why he put out the article. So him removing it didn't cost him anything, and he got extra value by making the thing public. So this is one thing. If you don't have that much of an audience, then it really boils down to what are you getting out of it, right? And maybe you should comply with the bully, maybe you shouldn't. Really depends on what if the bully keeps at it? What if they do take you to court? Are you willing to fight, or are you going to surrender then? Or, is there a way for you to let the world know? There's a lot of those organizations like TechCrunch and EFF. They love stories like this when big companies attack little guys for no good reason, right? And that's one way today to confront this, even if you don't personally have a big audience, is like, hey, look what they're doing, right? But
I feel like he would get a lot of attention. Like, it seems, I cannot imagine if Hootsuite would actually take somebody to court. When I was looking into the story and I was typing in Hootsuite lawsuit or sues or whatever, I noticed that they actually have had a lot of lawsuits. They do have a legal team on retainer who's probably just out there just looking for work, so they're just out there like, who can we mess with? Because they're billing Hootsuite by the hour, and they're just,
they got to justify their existence.
Yeah, right. And so they've had lawsuits, and I was looking into some. We won't get into it, like for whatever reason, some they dropped. People are suing them. They're suing other people. It's kind of weird, but like, I just can't imagine Hootsuite actually taking somebody to court.
Well, look, here are the official statistics. 97% of all lawsuits settle before they're heard by the judge, and before the judge has a chance to issue the final decision, right? So, in most cases, you never really know what was the right and the wrong thing to do, because people settle in the middle, and really all the legal paperwork is just a way to force people to settle. So, that's how law
Andrei,
works.
What do you think about if they really want to bully people and they just put them through litigation? Let's say they do start filing court documents, and now you do have to respond and so on, right? Like, that alone could be annoying.
Yeah,
right. Do you think that that's something they could be doing just to mess with people? Like, knowing they're not going to actually go all the way. They just want to mess with you, and they just start actually
it's
sending
extremely
files.
different. So in theory, as a defense, you can claim, you can ask the court to throw it out if you can prove that it's a vexatious claim that they're only doing to mess with people without it having any real chance of success. But it's extremely difficult to prove that in court. So in most cases, as long as they have at least some color of right, it will not be thrown out of court. And so in this case, it wouldn't be. So if they did decide to sue in court, and he said, they're not good people, they're attacking me for no good reason, the judge would say, yeah, well, we'll figure it out in court, in trial. Right. Yeah, if they did wanted to pursue this, they could, right? Again, I don't think they would win, and even if they did win, I don't see how they would get.
The damage to their public perception, like the public opinion matters, and the permanent damage they risk to their brand. I can imagine they would just want to close this case up super fast and move on.
Yeah, and again, today. When everything is public and when everything can get public very quickly, you have to be very careful about how you enforce your rights. And Actually, I want to say it the other way around because, I'm a founder and CEO of a trademarking company. So what we do is we help companies create those rights, right? Protect their trademarking rights. And I want to be very clear that I'm not saying that it's okay for other people to steal other people's IP. It's not, right? But you have to be very smart and only go after people who actually create confusion on the marketplace by using a brand similar to yours to sell products or services that are similar to yours. In that case, there's nothing wrong, nothing unethical with you using all powers you got by the law to attack them, go to court, and sue them into Stone Age. You should protect your assets. But when it comes to stuff like this, it's you just have to. You have to get a little bit more adult, I guess, and not be triggered by people, saying things that you may not want to hear, and say, okay, how can we go after them? Well, let's sue them for trademark infringement. That's not
right. I think they should have messaged him and said, hey, Ian, really appreciate your post. You got some negative stuff. You got some positive stuff about us. We just have this issue with how you're using our logo over here. Would you mind adjusting it? That would have just been a polite, cool. I think Ian would have been for sure. If they messaged me like that, I'd be like, sure. No, I would respect their brand. I do respect Hootsuite as a business, as a company. And Ryan Holmes, he's from Vancouver, who started it, is a Vancouver-based thing. I got mad respect for him. Yeah. So if they ever messaged me and said, hey, would you mind doing this? I'd be like, cool, no problem. But when they start coming at you with lawyers, which I bet the Hootsuite marketing department and the legal department are not communicating, so this legal department is out there just looking for things to bill. That's probably what's going on. And they gotta maybe be put in check.
I would guess that that's the case. I mean, as the company grows, very rarely would everyone in the marketing know what the legal is doing.
Yeah, no way. Andrei, you brought up an important point that I want to just touch on before we wrap up here is the purpose of a trademark. You just touched on it, but the purpose of a trademark, from what I understand and what you've taught me about this, is it's about avoiding confusion in the marketplace. So when somebody hears this brand name, they know that is that belongs to this brand. And so when you're using someone's logo and name and it's making it seem like they're associated to you or that you are that brand, that's when issues come into place, right? Exactly. I would imagine if we put a Hootsuite watermark on all of our videos, that would definitely be an infringement of trademark because people would watch it and think that we're somehow associated to Hootsuite.
Yeah,
right?
if there's a risk of the people thinking that the video or whatever products or services you offer come from Hootsuite, endorsed by Hootsuite, or associated with Hootsuite, they're in the right to prevent that because they have no control over what you do, how the public perceives what your products and services. And that's the proper reason why the legal department should be involved, right? And you're absolutely right? If at first you don't need to get lawyers involved. You can, especially with, public personas like Ian, right? You could send a quick message, say, hey, you may not realize this, but this goes against our terms, blah, blah, blah. Would you mind removing? And if he ignores them or tells them to go F themselves, at that point, you can get lawyers involved and see, how far you can take that. But it always goes back to, is there a risk that the public would be confused into thinking that what they're getting is somehow endorsed by or connected with the brand owner?
Cool. Andrei, I just want to give a shout out to you. I know Andrew's I want to give you a shout out to for the listeners who are watching. I own the trademark for Web Friendly. I've owned it now for several years. I think we got it back in 2015 or 2016. Andrei helped me do that. Andrei's the founder of trademarkfactory.com. If you guys want a trademark, it is by far the best place to go. It's the only place that's going to guarantee you get the trademark or your money back, or you could roll it into another trademark, but they're going to assure that you can actually get the trademark, because you go through lawyers, they'll just charge you hourly and they'll tell you, yeah, you can get this trademark, but really it's just not something that's really trademarkable. Andrei also has a YouTube channel. Let's link it up in the what do you call those, cards or whatever. You guys can go check out. He's got a whole bunch of resources if you guys want to learn about trademarks. Everything I know about trademarks, literally everything I know about trademarks, I learned through Andrei and working with Andrei. Andrew's also, I think Andrew probably heard about Andrei through me, I'm guessing, and this is the first time that they've met. And Andrew's also in the process of getting some trademarks through Andrei's company as well. So
I didn't even realize that until we got to the interview. It's pretty cool.
Just to echo, I mean, Andrei and I have come across each other back in my Vancouver days, but yeah, you and I have never had a chance to really connect and swap battle stories or anything. But yeah, I did launch a full service YouTube agency in January, and I did not hesitate. Because I'd left Vancouver years ago, my bad, totally forgot about Trademark Factory, totally forgot about you guys. And then Matt reminded me, I'm like, oh yeah, geez, what am I doing? So I contacted your company right away and got the ball rolling and got the trademark submitted, the application submitted in Canada and the US. It's a very time consuming process. I've definitely been educated from all your content, Andrei. You do great work. I can only imagine the amount of business professionals out there that can sleep at night because you do what you do. I know I sound like I'm blowing smoke up your butt, but it's true because
I'm enjoying it.
I didn't realize that you could spend you could spend all this time, money, and effort building a brand. You could have the .com, you could have the social media, you could spend years building a brand, and then someone swoops in and gets the trademark and then sends you a cease and desist. And when I learned that from your content, that scared the bejesus out of me. And I was like, I am not doing anything else until I get the ball rolling with Trademark Factory. So I got huge props for you guys. I think you do great work.
Thanks.
You know what, guys? I got to mention this. There's been two things that having the web-friendly trademark has legitimately helped me with. One is I got the .com. So I was negotiating with the owners of the .com for years. They started at over $20,000. I ended up getting the .com for I think $5,000 because I told them, I learned from Andrei, I have the trademark. You cannot sell this name to anybody but me. And so I brought them down from 20,000 down to, I think it was 5,000. And the other one was if you want a username on a social media account. So on Pinterest, somebody else had registered pinterest.com/webfriendly, but it was not being used. So I went through their help section into trademark infringement and I put in a form. I showed them I own the trademark for web-friendly. Within a week, they gave me back the name. I was just talking to a mutual friend of ours, Monica, who owns the trademark, which she got through you, which was Collagen Babe. Mm-hmm. Her Instagram account got hacked. Wow. So she's been trying to follow the process to get it back. And then the account that got hacked has been messaging me. So I was like, hey, you should really do something about this. And she's like, I don't know what to do. I said, well, go to this help section, which is about trademark infringement, and tell them that you own the trademark for Collagen Babe. So she's now in that process. So I'm sure we're going to hear back from her within a week or so that she'll get that username back. So that's just two instances of how I've actually used a trademark to protect my brand.
Cool.
All right, guys, let's wrap it up. Thank you, Andrei, for coming on the show with us. And let's get on to the next story.
All right. Thanks for having me.
Cool. Thanks, Andrei.